This interview is a part of the Oklahoma Historical Society's Oral History Program, Living Legends Collection. This interview was originally conducted on December the 6th, 1967. The interview is conducted by Mr. Raymond Fields. The interviewee is Mr. Earl Boyd Pierce of Muskogee, Oklahoma. This interview is being re-recorded on April the 16th, 1985, for inclusion in the permanent collections of the Oral History Program by Judith Michener.
In Muskogee, this 6th day of December, 1967, we want to introduce to you Mr. Earl Boyd Pierce, General Counsel of the Cherokee tribe. Concerning Cherokee Indian affairs, would I impose on you if I ask that you give that speech for the Living Legend Library?
Well, Mr. Fields, it is indeed a distinct honor and privilege that you've given me that on this day here in Muskogee, I find it possible that to do this as you requested, but I'm very happy to cooperate with the great program which you have undertaken. I doubt that that I have the capacity to perform the service which you are anticipating that should be done on behalf of the Cherokee people. But I'll be delighted to comply with your wish. I would think, Mr. Fields, that the service which you are perfecting for the future generations of Oklahomans, that you first, or they, looking into the future, would want to know something about the Cherokee people, and in a very brief way, as I may be able to present it, something about their history, much of it, of course, gleaned from published works, but some of the information which I am able to present has been accumulated over a long period of time by me in my research work in the various libraries of this nation. Since 1939, I have been an advisor to the constituted authorities of the modern Cherokees. At present, I am their general counsel. Native born among them, with my name included upon their rolls, I have never forsaken them, nor denied them. As a student of history, I have come to know some of the facts pertaining to their unique relationship to the government and to the people of the United States, with whom by treaty and other law the Cherokees have been bound since 1785. The first treaty between the United States and the Cherokee Nation was executed on November 28, 1785, and provided in part as follows. Article 3. The said Indians for themselves and their respective tribes and towns do acknowledge all the Cherokees to be under the protection of the United States of America and of no other sovereign whosoever. Article 2 of the Treaty of July 2nd, 1791, between the Cherokee Nation and the United States, provided in part that, and I quote, the undersigned chiefs and warriors for themselves and all parts of the Cherokee Nation do acknowledge themselves and the said Cherokee Nation to be under the protection of the United States of America and of no other sovereign whosoever. Under the above treaty provisions, and under Article 1, Section 8 of the Constitution of the United States, the Cherokee Nation became a dependent Indian nation under protection and control of the United States. See Cherokee Nation versus Georgia, 30 United States Reports, page 1. Choctaw Nation versus the United States, 119 U.S. Reports, page 1. United States versus Creek Nation, 295 United States Reports, 103. And Seminole Nation versus the United States, 316 U.S. Reports, 286. The Cherokees are now and have been for more than 130 years a literate people. Hundreds of them today are college graduates. Representatives of the tribe may be found in almost every vocation and calling in the United States. Like other Americans, a few, for example, the Venerable Sequoyah and the late Senator Robert L. Owen, who, with Carter Glass of Virginia, wrote the Federal Reserve Bank Act in 1913, and Will Rogers and W. W. Keeler of Bartlesville, Oklahoma, are renowned. Some are moderately rich, others are fairly well-to-do, and a large number in affluence and ability are regarded as average American citizens. The great majority of our full-bloods, however, though blameless, have not kept fully in step with the march and progress of their fellow citizens. But even this condition is not peculiar to the Cherokees, for this, we truly regret to say, is the fate of others also. In 1827, 12 years before the resettlement of the largest band, numbering 18,000 in present Oklahoma, the Cherokees had successfully adopted the customs, usages, ways, laws, and religion of their white neighbors in Georgia and Tennessee without any cost to the government, and completely upon their own resources. They established and maintained in Georgia and brought to Oklahoma the first free system of public education for their children in world history. Notwithstanding the tragedy of removal in 1839 and in the reduction of their country to ashes in 1861 to 1865 by the war between the states, at statehood in Oklahoma in 1907, they turned over to the new state a college and 126 public schools, and filled practically every courthouse and every schoolhouse in their counties in eastern Oklahoma with men and women of talent and competency. From that year until now, the Indians of Oklahoma, including the Cherokees, have provided leadership in every vocation and calling and have added immeasurably to the educational, socioeconomic, and cultural development of our state. In Georgia, long before coming to Indian Territory, they had formulated and erected a political government suitable to their needs under a written constitution with 3 branches patterned after the governments of the surrounding states, under the name and style of the Cherokee Nation. Their chosen leaders were intelligent, articulate, and dedicated to the highest elevation of civilized culture and to the absolute protection of their property rights. With the acknowledged understanding and respect of some of the most eminent leaders of the national government, including Senators Daniel Webster, John C. Calhoun, and Henry Clay, the Cherokees were able to forestall ouster from their ancient domain east of the Mississippi River for more than a decade, even against the iron determination and will of Andrew Jackson. Finally, in 1838, by force of arms and inferentially in defiance of the Supreme Court of the United States, the Cherokees were rounded up and in the fall and winter were removed in 13 detachments over the Trail of Tears to their present homeland in northeast Oklahoma. Their line of march and destination ended at a place where, by virtue of the terms of a previous treaty with the government, dated May 6, 1828, a large band of the tribe, known as the Western or Old Settler Cherokees, some 6,000 in number, under the leadership of Ulatika, or John Jolly, the foster father of Sam Houston, had voluntarily immigrated 9 years before. This band held to the belief, backed up by treaty, that all of the Cherokee land in Indian Territory, more than 13 million acres, for which their 4 million acres in Arkansas had been exchanged, were exclusively their own. For 63 years they were compelled to wait before a forum was provided in which to test the validity of their treaty, only to be told that they had been mistaken. But then Sequoyah and the other signers had long before passed away. In the 1830s, apparently the great aim of the government was to settle up and civilize as speedily as possible the Louisiana Purchase. The 5 civilized tribes were removed against their will and placed with fee titles along the southwestern frontier. They constituted a buffer and protection against the Indians of the plains to ensure the settlement without difficulty of Arkansas and other states. Viewed solely from the government standpoint, it was indeed a wise and effective policy. In our case, however, the Treaty of Removal has been denounced by the Court of Claims as early as 1891 as being the act and deed of neither the Eastern nor Western Cherokees. It was indeed an imposition of the gravest character, if not a fraud, upon our people. Its execution led directly to the assassination on June the 22nd, 1839, of its leading signers, friends of Jackson and of the government, many of whom were the most brilliant of our tribe. Then followed, as a dreadful consequence, a period of tragedy and turmoil within the tribe, touching every leading family, and ending in 1846, after, it is said, over 400 of our finest men had met their deaths, in a conflict where it appeared the Cherokees were about to commit national suicide. In 1802, 33 years before the execution of this treaty, history teaches that the government under President Jefferson had promised Georgia that it would extinguish the title of all lands of the Cherokees and the Creeks within her chartered limits in consideration of Georgia relinquishing title to its western lands to the United States, the present states of Mississippi and Alabama. Georgia ceded her lands, But since the promise to remove the tribes was made with the double condition that tribal consent would be first obtained and the title of the Indians extinguished upon peaceable terms, the government procrastinated until the election of Andrew Jackson in 1828. Georgia then moved by enacting repressive legislation against the Cherokees, thereby making their existence in Georgia unbearable and hastening the execution of the ill-fated Treaty of 1835. This treaty was executed by leading Cherokees who were not possessed of any delegated authority to bind either the government of the Cherokees or its people. By a one-vote majority in the United States Senate, this treaty was ratified. Van Buren, Jackson's successor, employed federal troops to enforce it and brought on the exodus. The not wholly unexpected result of the government policy to remove the Cherokees actually created three powerful divisions within the tribe, whose problems for a century and a half thereafter and until this day have engaged almost the constant attention of several branches of the federal government. Historically, the Eastern or immigrant Cherokees, the Western or Old Settler Cherokees, and the Treaty Party, so-called, comprise three very large components within our tribe, and each as separate bands have been congressionally recognized. In addition to the above mentioned federally recognized bands, there exist 8 other important intertribal business, social, and religious bands whose rituals, traditions, and affairs and leaders are generally known and respected by everyone deeply acquainted with the Cherokee people. These bands, together with the approximate dates of their respective origins, are as follows. The Seven Clans Society, ancient. The Four Mothers Society with some full-blood Creek members, ancient. The Texas Cherokees, 1819. The Kituwa Society, 1856. The Nighthawk Kituwas, 1861. The United Kituwa Band, a federal corporation, 1950. The Delaware Cherokees, 1867. The Shawnee Cherokees, 1868. The latter two bands are the descendants of those Delawares and Shawnees who purchased property rights in the Cherokee Nation pursuant to the terms of Article 15 of the Cherokee Treaty of July the 19th, 1866. All of these bands are familiarly known to the government, and together with the 3 federally recognized bands mentioned above, who in the aggregate number more than 35,000 on the rolls of the tribe, are commonly known as members of or citizens of the Cherokee Nation or tribe of Indians by blood. They actually constitute the tribe today. Considerable overlapping of membership within these bands is generally well known. When the Commission to the 5 civilized tribes, also known as the Dawes Commission, and its successors took over the tribal government, including its enrollment records, pursuant to a series of federal statutes aimed for the dissolution of the tribal government, commencing in 1893, 2 other groups, political citizens of the political government known as the Cherokee Nation, of non-Indian blood, the intermarried whites, and the freedmen, the latter ex-slaves formerly owned by individual Cherokees, and their descendants were listed upon separate rolls prepared by the Dawes Commission, which had been directed by federal statutes and federal court decisions, thus allowing to these people equal interest and participation in the distribution of Cherokee tribal property, including lands and money. Oklahoma would be confronted with the same situation if today its public lands and public buildings were ordered sold and distributed per capita among all the citizens of the state. For the interest of students of government, I mention here the citations to the statutes which accomplish this federal purpose: 27 Stat 612, 28 Stat 910, 29 Stat 321. Stat 716, 33 Stat 189, 34 Stat 137, and 35 Stat 312. All references are to the United States statutes at large. As should have been expected, as the reported cases will show, considerable federal litigation arose out of this situation. And from the Cherokee standpoint, many of the legal problems to this day remain unsettled, some of which are now pending in the courts in Washington. The original, final rolls of all political citizens of the Cherokee national government, when closed by order of Congress on March the 4th, 1907, contained in the aggregate 41,889 persons, including full and lesser degrees of Cherokee blood, adopted Delawares and Shawnees, intermarried whites, and freedmen. Congress further directed that allotments of lands in severalty from our feet titled tribal domains to the political citizens of the Cherokee Nation be based upon these federal rolls. The final act of the Congress in the series designed to end the Cherokee government and to pave the way for statehood, dated April 26, 1906, 34 Stat 137, for reasons then best known to Congress, but which indeed are disclosed in the legislative history of the Act. In its last section, Section 28, made a distinction between the tribe itself and the tribal government, and continued indefinitely both institutions as they exist in the 5 civilized tribes in Oklahoma in the following words. Section 28, the tribal existence and present tribal governments of the Choctaw, Chickasaw, Cherokee, Creek, and Seminole tribes or nations are hereby continued in full force and effect for all purposes authorized by law until otherwise provided by law. End of quote. This provision of federal law has remained unchanged from the date of its enactment in 1906. Under its authority, the Cherokees through the years, by direction of special jurisdictional acts, and especially since 1946, when Congress, for the first time in all its history, established a general legal forum for the purpose, have been enabled to litigate some of its legal and moral claims against the people and the government of the United States. Recently, one of our most noted cases, after 15 years of legal effort in the court before the Federal Indian Claims Commission in Washington, resulted in a judgment in our favor for $14,789,000. The commission held on the basis of the trial record that in 1893 the Cherokees, against their will and for an unconscionable consideration, had been forced under duress to deed to the government 6,022,000 acres of their fee title land, known as the Cherokee Outlet in northwest Oklahoma. This land was the object of the famed Oklahoma Run in September 1893. In that run, 40,000 American citizens were given homesteads of and 60 acres each, while later in 1902, the 41,000 citizens of the Cherokee Nation were allotted the remainder of their fee title domain in eastern Oklahoma, an average of 110 acres each, including the Flint Hills, where so many of our full-bloods then and now live. For lack of merit, the Attorney General, Honorable Robert F. Kennedy, decided not to appeal the outlet case. Thereafter, Congress paid the judgment and directed the Treasury to set up the account on its books in trust for the tribe. Further, in 1962, Congress directed per capita payments to be made from these trust funds to all persons or their heirs whose names appear upon the final rolls of the Cherokee Nation as finalized by the Dawes Commissions in 1907. The Bureau of Indian Affairs, under direction of the Secretary of the Interior, was entrusted with this duty, and the work presently is being concluded at Muskogee. More than 100,000 individuals, it is said, have received benefits from this judgment, while a sum in excess of $2 million is reverted to the tribe under the express terms of the distribution bill. The Act of 1962 further provided that the reverted funds could be advanced and expended for any tribal purpose determined feasible by our principal chief and approved by the Secretary of the Interior. At the moment, our chief, the Honorable W.W. Keeler of Bartlesville, and the Executive Committee, with departmental approval, are engaged in an effort to rehabilitate the less fortunate members of the tribe with proper use of our own funds. We did this very thing for 75 years unaided before statehood, and if need be, we can do it again. Programs to meet housing needs and educational loans for our worthy youngsters are being implemented, and other like programs question is, are we too late? The chief and the government do not think so. Elements of President Johnson's far-reaching, humane, and economic program have already reached the Cherokees. In September 1964, Washington asked the tribe to sponsor a neighborhood youth corps for our high school youngsters and dropouts. It accepted the responsibility, and over $1 million since then has been spent in the NYC program. Well over 1,000 youngsters from extremely low-income families, with many families earning less than $1,500 per year, have been benefited. 95% of this sum has been earned by the students and has been paid to them. Far too many of the students had never before had the opportunity to earn a single dollar. And you can well imagine what these benefits have meant to them. Before NYC came, the girls as well as the boys were dropping out of school for lack of decent wearable clothing. In many families, soap was a luxury, and the endless routine of being compelled to seek welfare commodities for their total subsistence and other kindred causes and conditions which for so long has prevailed in the area had taken its shocking toll among this deeply religious and now most gentle and enlightened people. NYC has helped to improve the whole picture. At least our youngsters are now inspired to stay in school. Their teachers all agree that relief arrived in time to save several who now are in college continuing their education. Of the NYC graduates last June, 52% went on to college as compared to the national average of 40% for all graduates in the United States. The citizens of Oklahoma, and especially the Cherokees, are proud of this achievement, and we trust the government will see that it is continued. Among these youngsters will be found not one unpatriotic enough to burn his draft card or to march in defiance of the determined will and policy of our government. Indeed, a considerable number as volunteers are now in Vietnam. And you may rest assured that the Cherokees will ever stand firm and strong in their loyalty to the great and good government of the United States. I thank you.
This representative of the Living Legend Library of Oklahoma Christian College, Oklahoma City, desires to make a footnote concerning Mr. Earl Boyd Pierce. Mr. Pierce is a widely known historian, particularly is he acquainted with the history of the Cherokee Nation. He is a member himself of this tribe and has recently won a $14 million award for his Indian compatriots through the Congress of the United States and the Bureau of Indian Affairs on appeals. Mr. Pierce has given us the background of the Cherokee Nation, which is a very interesting document for.
This interview ends in the middle of a sentence, which indicates that Mr. Fields must have run out of tape before he completed this interview with Mr. Pierce. We have copied this material exactly as it appears on the original reel-to-reel Living Legend tape.